Creator of all that is, ubiquitous, encompassing, profound. Tuning into this energy of the divine is humbling and empowering all at once. That is one of the mysteries, the minuscule and the majuscule. Our part right here, right now, is why we are here, why we are tuning in. We are our purpose. Consider no predator and no prey, just us awash in divine energy with all its movement and play. When we do this, there is peace within. When there is peace within, there is gratitude. Where there is gratitude, there is clarity and direction that we are here to take responsibility now that we know who we are. We are of source, of creator energy, and so it is.
Hello, my name's Ron Vroman. I'm the old white man talking head for the Oregon Statewide Jural Assembly. This is Subpoena the Sheriffs. Let's fix this. Subpoena ducis tecum and subpoena testificandum. The basic original jurisdiction source materials are Oregon's Constitution circa 1859 and the United States of America's Constitution circa 1859 with Bouvier's Law Dictionary 6th edition 2 volume 1856, governing law and the dictionary for definitions. Then provide these subpoenas to those that are and should not be, such as 36 sheriffs on Oregon, 38 Oregon prosecutors, 36 DAs, 1 Attorney General, and 1 JAG for the National Guard. Article 7 amended, judges without good behavior, proper bona fides, oath and bond, ability, Oregon State Bar, Oregon State Police, Oregon National Guard, and the Department of Corrections are all without bona fides because they cannot meet or exceed the standards required. They must comply to an audit of their bona fides or vacate the office or position. Our civilian common law court of record will assist anyone in fulfilling their obligations and responsibilities. We have the solution, at least a solution. Our court is the nomenclature, and it starts with province, page 437, Bouvier's 1856. It is the province of the court to judge the law and of the jury to decide the facts. As recently decided and affirmed by the Fifth Appellate and SCOTUS, that it takes an Amendment 7 required and an Article 3 recommended in SEC versus Jacarcy 603, United States 109, 2024. The exact civilian common law court of record that we have on Oregon. A complete and common understanding. It is all written down, and we and you need no opinion from legal. Find unfettered counsel. This is your oath and your contract with Article 1, Section 1. Article 3 with original jurisdiction, Article 7. Amendment 7, Civilian Common Law Court of Record. See the Chevron and SEC Jacarcy. Signed, sealed, stamped, witnessed, proof of service, and published on 3 cable TV channels, YouTube and Brighteon, and www.orsja.org. And we've been doing this for 7 years without rebuttal, one step at a time. That counts. Courts decide the law and juries judge the facts. We have that court and jury. We need our sheriffs. See Bouvier's Law Dictionary, 6th edition, 2 volume, 1856, available on Amazon, and it's printed in Troutdale, Oregon. The United States of America's Constitution circa 1859. That's law. ORS 206, DPSST, Oath and Bondability, Country HR, and County Recorder. Those are requirements. Once your Jural sheriffs are in place and the proper papers may be served, informing the Secretary of State, the Department of Corrections, Oregon State Police, and Oregon National Guard what is required constitutionally, provisionally, until proper elections can be held. That takes a proper Secretary of State and Deputy Secretary of State. Our civilian common law court of record is researching subordination of perjury. Page 607, Bouvier's 1856, investigating the existence of Article 7 amended in de facto, incorporated color of law recooperation of the Oregon State Bar and or its members, including the judiciary. Additionally, good behavior is the key. Self-correct with the proper oath. Using this position with Article 7 amended is proof of not good behavior. We are no longer deceived. The claims are made and published by each of you named and for the office you claim. Provide your bona fides of office. You all make the claims of who you are, how you have the authority, and each is held to a published requirement. It's a standard. We have found no evidence of your claims, Article 7 amended, and all the ORS about the Oregon State Bar. Caveat to will and probate in open court. Prosecutorial discretion is extensively practiced to deter action against the state and its bad actors. Article 7 amended de facto by definition. In common law, the principle of prosecutorial discretion allows public prosecutors a wide latitude to decide whether or not to charge a person of a crime and which charge to file. The Bar, Guild, PMA, Attorneys Union, ABA, Esquires, JD's Association of the Oregon State Bar, which Charlie has recently challenged on behalf of our provisional Article 1, Section 1 government on Oregon, supporting and agreeing with Gary's brief on the Oregon judiciary, Article 7 amended. It contradicts our Bill of Rights and Oregon's Constitution circa 1859 and the United States of America's Constitution circa 1859. Does it fail at the first known defect? This goes back to Matthew Deedes, 2 books about Oregon. They both published the same lie. Amendment 13 XIII, Anti-Titles of Nobility. Remember Frank Benson, Secretary of State and Governor at the same time, which is a constitutional impossibility, gave us November 8th, 1910, Article 7 amended. And that has, to this day, no supporting evidence in fact. That has been acquiesced to and defaulted to by the state of Oregon, aka State of Oregon in all caps, a de facto subdivision of the United States of Washington District of Columbia, Inc. in some form since 1861. Did I mention we are no longer deceived? We also do stuff. We are pretty good at doing stuff, such as returning to a Jural, constitutional, Republican form of government, Article 4, Amendment 4. These two documents for sure are in the contract between those that Oregon proposed in 1857 and the Constitution brought back. They have a reprint of the longhand 1857 version for sale, Secretary of State. What was actually ratified by the several states of the Confederation and Perpetual Union, styled the United States of America, is unobtainium from the State Archives Office of the Secretary of State. On 3 separate occasions in the flesh, we have made attempts with 3 secretaries of state and 3 under or deputy secretaries of state. Emails and phone calls abound. There is a third document, Bouvier's Law Dictionary. We read in our Constitution's Amendment 7, then we define what suits in common law, courts and jury, and judges' law, and who defines the facts, and who can move to equity. SCOTUS in the United States federal district courts are not Article 3 courts, nor Amendment 7. Therefore, they lack the bona fides to try a man or a woman against the state. This also applies to the current state, county, and municipal and other courts, such as justice on Oregon or in the de facto Salem oligarchy. When taking one step at a time, knowing we are moving away from all that Kate Brown stands for and moving towards a constitutional Republican form of government, Article 4, Section 4. This includes all the political parties that subscribe to the de facto and that operated Oregon since the fraud of 1910. The ones that broke their oath, January 21st, 2021. The ones that participated in the homicide of Robert Levoy Finicum, rest in peace. The picture is clear. Without a proper oath and bondability to the proper constitution, with the laws of nature and nature's God included, moving through all that comes before us, returning to the path to our constitutional Republican form of government this year, 2025. The current step includes proper bona fides, as as it is analog and not digital or de facto. It's jure and provisional until we have the office of sheriff properly occupied by our sheriffs. I yield.
My name is Gary Dean of the Family Derby. We are asking, where are our sheriffs? For the last several months, we have posted and made available what we worked on as a proper oath for the persons in our government. Sheriffs are our first effort at our insisting on a proper oath. For it is the sheriffs who are here in their county position to protect and defend the people. Protect from what, you may say? From ticketing or sending people to the illegitimate amended Article 7 courts that should not be. From governance overreach and taxation, that they should assist seniors in the prevention of their eviction from their loss of equity, their forever home, and all that they possess. Our Article 3, Amendment 7 Civilian Common Law Court of Record has made numerous visits and relentless communications to our county sheriffs on Oregon to offer a remedy from victimization of the people. How? You might ask. It's like a shift in the mind. It is the recognition of one's allegiance to life and that which is God-given, rather than criminalizing living God-made beings for a dead corporate entity. Our sheriffs are our first protection against governance overreach. The significance of elected government officials taking a proper oath to the original jurisdiction Constitution, SIRA 1859, is a tremendous recognition. The oath, then, is a promise to our God self, to our Creator, God, and to people, not persons. Such a juration, taking a solemn oath, is needed for there to be remedy in our authoritative system of governance. Once a sheriff can make the shift, they can see themselves among the people rather than among the corporate entity meant to enforce our compliance to the bidding of the state. This cognition promises to be a release of tension, greater freedom, and cooperation. Let it be so.
They do not want to let go of this. They do not intend on losing here. And we do not intend giving it back to them.
And then the bullets started flying, and then he jumps out of the car, and he's got both his hands up. And he got out of the car, and he had his hands in the air. He's like, just shoot me then. This is what you want, to shoot me. And they did. They shot him dead. With his hands in the air, and I saw it. I swear to God. He was just walking with his hands in the air. And they shot him. And they shot him dead, and then after he was down on the ground, they shot him 3 more times.